Morning. Today's date is April 1st, 2021, and we are scheduled for one oral argument this morning. It's the case of Dora Makse versus the Summit County Executive. It's case number 29747. I'm Judge Teodosio. I'll be presiding. Joining me on the panel, as you see, is Judge Lynn Callahan and Judge Betty Sutton. Each of you will have 15 minutes to present your arguments this morning. The appellant may reserve up to 5 minutes for rebuttal. Attorney for the appellant, if you would like to reserve time, let the court know. Judge Callahan's going to be keeping track of time, so she can let you know as you approach your rebuttal time. And that way you can decide to continue arguing or reserve what's left for rebuttal. I'm assuming you have, you'll be kind enough to do that for the court, Judge Callahan?
I will.
All right, thank you. This argument is being visually and audibly recorded. And as you know, we're live streaming on the court's YouTube channel. A link to the video will also appear on the court's website for those who are interested. Counsel, if you would please mute your microphones while you're not arguing so as to minimize distractions. While I don't think it's applicable here, we always do remind counsel that we don't use the names of victims or minors. It's just a good public service announcement because I know that's not the case here. The judges have read the briefs in this matter and we are prepared to proceed when you are. So counsel.
Good morning, Your Honors. My name is Merritt Willis Hanna and I'll be arguing for the Summit County Executive. At this time, I'd like to reserve 5 minutes for rebuttal.
Okay.
And I would just like to start by saying that this is an administrative appeal. Ms. Makse, was terminated in March of 2019, I believe. Lost my papers here. Yes, March 27th, 2019. She appealed to the Human Resources Commission and a hearing officer was appointed to conduct an evidentiary hearing, whereupon the hearing officer found that termination was supported by the preponderance of the evidence. She laid out her findings in a thorough order, and the Human Resources Commission adopted those findings. Thereafter, Ms. Makse appealed to the Summit County Court of Common Pleas. That was right at the time when COVID hit and our proceedings were a little strange. We were all new to this. We did not have any hearings. The court ended up entering an order on April 13th, 2020. And from that order, we have appealed to this court. I'd like to make it clear that we're not asking the court to substitute its judgment for that of the Common Pleas Court. We're rather frustrated with this order and the lack of guidance in this order. We find it confusing in that the trial court seems to make findings of fact, although the court characterizes those findings as just referencing the complaints that were made. It goes through a list of what may be facts, and those facts are similarly represented in the hearing officer's findings and conclusions of law. And when you compare the two orders side by side, you'll find they seem to reflect the same evidence. That this is how we were looking at this order. So what we take it as is that the court really, although he agreed with the findings of the hearing officer, he did not feel that the hearing officer, who was in the best position to judge what the administrative entity was doing and most familiar with the administrative agency's policies, he felt that termination was not warranted and that suspension was not warranted and that demotion was not warranted, I believe. In the end, the court found that, or makes this a finding, I believe that by preponderance of the evidence, the commission's order was not supported. And we're not asking this court to come in and say that the trial court or to weigh what the trial court did. I'm asking this court to find that the trial court, or the common pleas court, excuse me, abused its discretion in making those findings by substituting its judgment for that of the administrative body. And in that, that the administrative body, the administrative HRC, Human Resources Commission for Summit County, felt that the remarks, the comments, the willful failure to complete her duties rose to the level of termination in this situation, in as much as Ms. Makse was a supervisor. She had 9 employees reporting to her and admitted to her supervisors, which the Common Pleas Court also found, that she was avoiding Black staff. This is an untenable situation for the Department of Jobs and Family Services and for the county to have a supervisor who was willfully refusing to engage in her duties. And the best body to make that judgment would have been the Human Resources Commission. So it's our position that the Common Pleas Court really substituted its judgment as far as the human resources aspect in reversing the reversing the Human Resources Commission's decision to demote Ms. Makse and to require more training.
Well, the court did set forth a limited statement of facts. I think it was in the second paragraph of its order. And it ultimately did what it was supposed to do. Didn't it make a finding that the commission, the decision of the commission was not supported by a preponderance of substantial, reliable, and probative evidence? While the facts may be sparse, I don't know of any authority that says the court had to set forth a detailed analysis of the facts in the case. All it had to do is make that decision as to whether or not the decision of the HRC was supported by a preponderance of substantial, reliable, and probative evidence. What am I missing there?
I don't think you're missing anything. What I think the county's issue with this specific order is because the court specifically says in the second sentence of the second paragraph of the order, the complaints included. Is the court finding at that point that these are actual facts, or this is evidence, or is the court just explaining how it got here? That's one issue. And I felt when we were going through and preparing this, that we were dealing with a lot of negatives. We weren't actually, I was looking at, was this an unconstitutional issue? Was there sufficient evidence? There was evidence that the HRC found. And the court seems to, if you take that paragraph as a finding, seems to have found the same evidence. So there existed evidence, and we're dealing with a preponderance standard. We're not dealing with a beyond reasonable doubt or clear and convincing evidence. We're dealing with the greater weight of the evidence, or that it's more likely than not that the agency met its burden and that the charged offenses occurred. So our position is that the court mirrored what the HRC found, and that HRC finding consisted of evidence, which would meet the preponderance of the evidence standard, and the court just decided it didn't like the outcome. And in that respect, we are asking this court to reverse, to find that the Common Pleas Court abused its discretion in reversing the finding of the Human Resources Commission. And I don't want to belabor the point. If the court has no further questions, we'll rest on our brief and wait for rebuttal.
Thank you, Attorney Willis. Any questions, Judge Callahan? And what about you, Judge Sutton? No? All right, thank you, Attorney Willis. We'll hear from Attorney Grimm.
All right, now you might hear from Attorney Grimm. Sorry about that. I need to do a little bit of housekeeping first. First of all, just as we started the argument, a cement truck started pouring outside my office. I think they've moved away, so I think the background noise won't be a problem. But at the moment, it's all right. My second little bit of housekeeping is very rarely, but occasionally my computer cuts off without warning. If I disappear, I just have to sign back in after power's down. So I'll be back. I hope by saying this that will be the magic that will keep that from happening. And the third thing is I need to apologize. You may have noticed an odd notation on page 12 of my brief after some citations, and it says boldly, error, bookmark not defined. I actually don't know what I did wrong, but apparently I only did it on that page. So if you can get through that page, we should be okay in the reading. I apologize for that. Okay, so thank you for giving us this opportunity to argue today. The facts have been argued extensively by both sides in the briefs. The facts were, of course, at all levels, there was a transcript. Well, at the first level, the hearing officer, of course, heard the facts, and there was a full transcript available to the Human Resource Commission and to the Common Pleas Court judge. So he clearly had a full set of facts. And there's no law that I'm aware of that requires an express finding of facts in the decision of the Court of Common Pleas. I think the most important, I'm happy to discuss any of the facts that you wish to discuss, but the first thing that I think is always important in any appeal, and particularly administrative appeals, is the standard of review, because it's a little bit, I mean, it's unusual in terms of other proceedings don't have the same standard. And it's very important in these cases. So number one, because this is an employment case, the public employer has the burden of proof and had the burden of proof before the Human Resource Commission. And that takes place in the context of the employer's own policies, which are in the record, the Summit County Personnel Policy. And those policies provide for, it's a certain sort of progressive discipline policy. It doesn't say that one absolutely must progress from stage to stage, but it does say to skip steps, it must be a major offense, I apologize, as defined in the policy. So that's very important. And that's what the county was required to prove, was that the behavior of which they were alleging of Dora Makse constituted a major offense, because she had no disciplinary record within the past 2 years, which is the standard under the policy. So as an administrative appeal, it seems from the briefing that the county and Ms. Makse both agree on what the standard is. We agree that this is at pages 16 to 17 of the county's brief. We agree that the Human Resource Commission decision is appealable. We agree that the standard for review at each level is set out in Revised Code section 2506.04 and in several decisions of the Supreme Court. And the county recognizes the standard for the Court of Common Pleas is different from the Court of Appeals. The Common Pleas Court is required to do a certain amount of weighing of the evidence and to determine whether the administrative order is unconstitutional, illegal, arbitrary, capricious, unreasonable, or unsupported by the preponderance of substantial, reliable, and probative evidence. A mouthful. This court, the Supreme Court has said many times, the authority of the Court of Appeals is more limited in scope. It's the traditional Court of Appeals standard of questions of law. And so to overrule, to find that an order was not supported by reliable in review of the trial court's determination that a decision was not supported by reliable, probative, and substantial evidence, this court must find whether the trial court abused its discretion. And the standard for that is noted by the Summit County in their brief. The standard for abuse of discretion is that the attitude of the common pleas court is unreasonable, arbitrary, or unconscionable. So one Supreme Court case that I think is important that the county did not mention in the brief is the very recent case of Shelley Materials, which actually comes out of my home county, the 11th District Court of Appeals in Portage County. In Shelley Materials, this was an appeal from a decision of the Planning Commission, and the Planning Commission made a decision to find that an applicant for a conditional use permit had not met its burden of proof. The common pleas court reversed this decision of the Planning Commission, and the critical difference was that the Planning Commission had dismissed the findings of an expert, a real estate appraiser, and the Court of Appeals found that the common pleas court found that the expert was qualified and there was an adequate basis to not credit the real estate appraiser, and that there wasn't other expert testimony. They had relied on the planning director, I think, which was not non-expert testimony. So in that case, the Court of Appeals then reversed the judgment of the Court of Common Pleas, but with a different view of the expert testimony and what was qualified expert testimony. So that went up to the Supreme Court, which basically said the Court of Common Pleas did what it was supposed to do in weighing the evidence, and the Court of Appeal did what it was not supposed to do because it weighed the evidence. I'm overly summarizing without getting into planning and zoning law in our case here, but basically found that the Court of Appeals had overstepped its bounds in making a different decision about how to evaluate the expert testimony because that was outside the bounds of the Court of Appeals. So the point here is that it's very important that I think what the county is asking this court to do is to weigh the evidence, to go back and say, we agree with the hearing officer and we agree with the Human Resource Commission on a weighing of how to interpret the testimony. And that's exactly what this court should not do, and that's what the Supreme Court said in the Shelley Materials case. And I think it's clear from just from the briefing of both sides that there are a lot of disputes about how to interpret the evidence, about what the evidence said. I would add that a lot of the county's evidence was hearsay. It was an employee made a complaint to, a lot of it was an employee made a complaint to the union representative, and the union representative brought the complaint to the manager, and the manager testified about what the complaint was. Now, not all of it was hearsay, but a lot of it was that. And in each of those instances, Dora Makse herself testified about, I think most of all of those, that was direct testimony. And also Misty Mitchell, who was a co-supervisor and was the county's witness, but she testified about some of those instances in which included testimony that actually favored Dora Makse. For example, one of the complaints that the managers testified about, Misty Mitchell said that didn't happen. So, my point here is just there was a lot of evidence in the transcripts, briefed thoroughly by both sides, or together, taking the briefs together, it's been thoroughly briefed. Clearly, there was much to review to determine whether or not the decision was supported by a preponderance of evidence. And I think the Court of Common Pleas was within his or its authority to make that decision and to determine whether or not the county, and of course the county's burden was not just simply to show that there were some complaints that should be taken seriously, but to show that the facts behind those complaints actually support the finding of a major offense, which justifies skipping the disciplinary steps and going to termination, as the hearing officer did in the first instance, or to 6 months suspension and demotion as the Human Resource Commission. And the Judge Haas actually said, hey, she should probably still get some training. That was a good idea, but the conduct as shown by the evidence did not, and by there was not a preponderance of evidence to support the finding of a major offense. So there's some reference in the county's brief to, argue that the cold words on the paper are not enough. Unfortunately, in any appeal, what we have is what might be called the cold words on the paper. We have a transcript. In this case, we have a thorough transcript. There's actually specific provisions in the administrative appeal law about what to do when there's not a transcript, but we didn't have that problem here. We had a transcript. So we didn't have a reason for example, more evidence at the Court of Common Pleas. And the under 2506, the Court of Common Pleas and the Court of Appeals have the right to review the transcript within the limits of the authority set out in the statute and the Supreme Court interpretations for each of those courts. Yeah, another issue that has not been argued by the county here at the oral argument, but a significant part of the county's brief was to argue that the court should consider evidence that they wanted to present about situations that occurred in 2017 and earlier. The Human Resource Commission and actually the hearing officer explicitly declined to consider that testimony, although it was offered. And that issue was never appealed at any earlier level by the county. That was clearly in line with the personnel policies of the county to not consider evidence of events that allegedly occurred more than 2 years ago, or to consider disciplinary attempts. There were 2 failed disciplinary attempts because the county was overruled in one case by the Human Resource Commission and agreed to withdraw a minor disciplinary complaint after that. So the Human Resource hearing officer properly decided not to, that evidence was improper. The Human Resource Commission did not consider that evidence, and it's improper for the court to, it would be improper for this court to dig into that evidence because, first of all, I think those are really, secondly, I think those rulings were correct, but also the county never did not challenge those rulings in the first place, and it's too late to do so now.
You have about 2 minutes.
Okay, well, I'll just get to my conclusion. We asked the court to affirm the decision of the Court of Common Pleas, to direct the county executive to reinstate Dora Makse to her previous position and classification at the current rate of pay for that position, as if she had continuously held it, or to an equivalent position with the same rate of pay and opportunities for promotion. The executive should be ordered to pay back pay both for the period when she was on an unpaid suspension and for the period after she was placed in the demotion position. There's been a continuing pay discrepancy, and she also should get back pay up to the date of reinstatement with interest from the date that each paycheck was due.
All right, thank you. Judge Callahan, any questions for Attorney Grimm?
No, thank
Judge
you.
Sutton? Anything? All right, thank you, Attorney Grimm. Attorney Willis, you are on rebuttal.
And you will have your full 5 minutes if you wish to use it.
Unmute yourself, please.
A little sign's flashing to unmute, and I'm still not doing it. I don't think I'll need the full 5 minutes. I just would like to say, I think, as Attorney Grimm pointed out, there is no law that requires a specific finding of fact, but it sure would be good to have one. That's what we're doing here. And we're asking this court to look at that order, which makes it more difficult in our appeal. If we don't have something substantive that we can come to and really review, that lack of specific findings of fact is crucial here. And it would have been helpful to have, again, reading the order, I can't tell that it's a finding of fact or if the court is just saying there were complaints. That makes it difficult for me to argue that this finding of fact was, that there was an abuse of discretion here with respect to what the trial court did. And I guess that's what I'm getting to, is that the lack of an order itself constitutes an abuse of discretion. And the court's acknowledgement, if we take it as that evidence existed, and that evidence is precisely what the hearing officer found, that the court's ignoring of that evidence and deciding that it's going to just tell the administrative body how it should discipline its employees, instead of looking at the facts and digging in and saying, okay, well, there was this, there was this, there was this. It makes it very difficult for us at this stage, at this juncture. So at this point, I would really just like to stop beating a dead horse and just to urge this court to reverse the lower court's findings and reinstate the Human Resources Commission's order demoting to a non-supervisory role and suspending without pay, and also ordering training. Thank you.
Thank you, Attorney Willis. Last chance for questions, Judge Callahan.
No.
Judge Sutton. All right, I want to thank counsel for your presentation today. We certainly appreciate your appearance by video. I also want to thank Judge Callahan for taking care of the time today. The court will take the matter under advisement, issue a written decision in due course. Of course, it will be mailed to both parties to this appeal. The decision is also posted on the Supreme Court of Ohio's website.